Mr. Human, can I ask you to read paragraph 11.2 into the record?
Chair, the heading is Aircraft Component Support, ATA Chapter Coverage, SP 462/15. The BAC considered the request to note SART's intention to award a tender for aircraft component support on ATA Chapter coverage for both Boeing and Airbus fleet to Air France Industries for a period of 5 years as per Chapter 25 of the SCM policy. The value of the contract for the 5-year period for Air France Industries is estimated at 1.346 billion rand.
Thank you. And read the BAC resolution.
The BAC resolved to round robin the submission as there was no sufficient quorum to make a decision on it.
Now, Mr. Human, the first sentence you read said the BAC considered the request to note SAAT's intention to award the tender. Does that accord with your understanding of what a BAC's role is?
The capturing of the sentence is because there was no quorum, and according to the terms of reference of the BAC, if there's not a minimum number of members, they do not have the mandate to make an award decision. So all that they could do in terms of their mandate was to note and defer it to a round robin process.
And can we then go to the minutes of the board, which considered it on referral from the BAC, and that is at 2305. Well, it starts at 2304.
Based on what is at 2302, the resolution, I would expect us to go to the round robin resolution before going to the minutes of the board, so that we know what the outcome of that round robin was before we go to the board.
Indeed, Chair. Chair, Ms. Hofmeyr is just helping me to see if we've got that resolution. I'm not sure that we do have the round robin resolution of the BAC.
Yeah, if we don't have, at least we must just know what the outcome was, so that the story can connect properly. Because the 2302 ends with a resolution to do a round robin.
Indeed. Chair, we don't have it, so we're going to have to do some further investigations to find it.
Do you by any chance know, Mr. Human, what happened, or you don't know?
Chair, unfortunately, I don't have a document close by hand.
Okay, all right.
Can we then go to page 2304, Mr. Human? This is the minutes of the special meeting of the SAAT board. And if we go over the page to 2305.
2304 is the one that has got 95 written by hand on it or something.
95A, Chair. That's the annexure number. It corresponds with the blue tab on the file. Yeah.
Just wish somebody could write somewhere, not on top of the page number.
Indeed, Chair.
Because it makes it difficult to see if it's what the number is, page number is. Okay, all right. You say we go to 2305.
2305.
Okay. Well, these are minutes of a meeting of the board of
South African Airways Technical.
SAAT held on, is it the 9th of May 2016? That's what, yeah, 29, not 29, 9 May 2016 at 8:30 in the morning. Yes, okay.
Can I ask you, Mr. Human, to read 4.1 of those minutes?
The submission was tabled and considered. According to the submission, management recommended that the tender be awarded to Air France. A decision on the matter ensued and the board made the following comments.
Can I pause you there, Mr. Human? Why would it say that management recommended?
It was customary that the EXCO of SART would also review and endorse recommendations. The referral to the word management, therefore, would represent EXCO.
Okay, continue.
A. Management's rationale for recommendations that Air France be awarded tender was not substantive, considering the bidder's resistance to align itself to SALT's developmental agenda, in other words, supplier development. Furthermore, the benefits as outlined by the submission as a result of selecting Air France were not compelling enough to position the latter as the preferred bidder. The concerns regarding JMAAR, especially management's view that this bidder was lowballing, could be mitigated by reducing each party's obligation as well as the terms and conditions to writing. Resolved that the request for approval of the award of the tender for the aircraft component support...
I'm sorry, Mr. Human, I'm sorry. Please don't forget where you were. Do you understand that last part, under resolved? I just want to make sure I understand it. No, not under resolved. The one which says the concerns regarding JM, excuse me, AAR, especially management's view that this bidder was lowballing, could be mitigated by reducing each party's obligations as well as terms and conditions to writing. How would putting those obligations in writing make any difference to the concerns of lowballing?
Chairperson, in such an instance, mitigating results would be, for instance, to increase the number of units in the main base kit. If one is worried that it's too, the price is below market rates and that you wouldn't get your components on time, a mitigation would be put 10 units instead of 5, then you at least know you have access. The concern here was, if the price is so low, doesn't that suggest that the company would not have the ability to deliver the parts as and when needed? Secondly, it's standard practice that once a contract is, a tender is awarded, there's a formal contract management process where the service level agreement, standard terms and conditions, pricing, performance indicators are recorded in a contract. It's reviewed by the legal department, and once that process is concluded, both parties sign. So the intention was to document specific mitigating measures as part of the contract to address the concern that because of the low cost, the quality and turnaround of the service wouldn't be compromised.
I'm not sure that you understood my question, or maybe we understand this part differently. You have told me what lowballing is and what the concern is with regard to lowballing and what the concerns would have been about lowballing. I'm concerned that what the board is saying here in this part is those concerns, which are, you are saying it's going to cost you 100 rand in your bid, but in all probability it's going to cost you 500 rand. So you are going to have a problem giving us what we expect. So you might end up lowering the standards, giving us poor quality of a product or something. That's the concern about lowballing.
That's correct, sir.
Now, my difficulty is when the board says here, those concerns can be addressed or can be mitigated by reducing the obligations to writing. Because how does that mitigate my concern that this service provider is going to end up not providing quality service because they didn't do justice to themselves by quoting too low a price? Do you understand what my concern is?
Yes, Chairperson.
Or do you read this part as meaning something other than what I understand it to mean? As I understand it, it seems to say, put the obligations of the parties in writing, where my concern is not that they are not, the obligations are not in writing, because the obligations are going to be in writing anyway.
Yes.
That's correct.
They are going to be in writing. My concern is those obligations, insofar as the price is so low, are going to put us into a problem, because when this supplier faces a problem of not being able to acquire A, B, C, D at this type of price, they are going to compromise on other things, and then I will suffer. Is that how you understand this, or do you understand it differently?
I understand it in the same manner.
In the same way.
Yes.
Yeah.
And
is it your understanding too that putting the obligations in writing won't really mitigate anything? What would mitigate is if you go to the supplier and say, let's increase your price. This price we have put on the table is not going to work, or something like that.
Chairperson, that's certainly a correct interpretation. In this case, the intent was a little different. It was to guarantee reliability of components. It was to ensure that any modifications that is issued by the manufacturers will be implemented. It is to ensure that there will be delivery as per the required time frame, because the argument, if it's so cheap, obviously one has to source wide, and it might compromise the turnaround time, while a more expensive unit might be more readily available, a new one, for instance. So those mitigating the board's request to document firmly how SART would ensure that the turnaround time is not compromised, and document roles and responsibilities, was the board's view of how to address the low cost. According to the evidence, there was no further price adjustment as part of risk mitigation in any shape or form that I'm aware of.
But we'll move away from the point just now. But it just seems to me that it's not a substantive addressing of the concerns. If you offer to get me a suit for 100 rand, and I'm concerned that you're not going to get a quality suit for 100 rand, how does it help for me to say, let's write it down that you say you'll get me a suit for 100 rand? Because you might just come back and say, I'm not getting it. Then I'm back to square one. Maybe it's after quite some time. Then I must say, okay, let's look for one that's 500 rand, but we have lost time in the meantime. Or I say, let me look for somebody else who knows what they are doing. Because I think you don't know what you are doing if you think you can get me a suit for 100 rand, and the fact that you didn't get it proves it. You understand that concept. The fact that we write it down doesn't seem to, for me, to address the substantive concern.
I read you.
You understand?
Loud and clear, Chairperson. You will get a T-shirt at most for $100 these days.
Yes, thank you, Mr. Mbiko. You may continue.
Thank you, Chair. I think, Mr. Human, you were in the middle of reading the resolution. Do you want to just complete that?
Chair, the resolution reads, the resolve that the request for approval of the award of the tender for the aircraft component support services on 88 chapter for both Boeing and Airbus fleet for a period of 5 years to AAR, B, and is hereby approved, subject to the mitigation of risks highlighted in the submission.
Thank you. Mr. Human, do you think that this...
I'm sorry, the mitigation of the risks highlighted in this submission, is that what we've just been talking about, or is it something else?
It's the very same thing, Chairperson.
Yes, okay, thank you.
Mr. Human, is this, in your view, the role that a board should be playing in a tender?
Yes, a board's role is not just to rubber stamp a submission. The board's role is to apply their mind in 3 ways. Has due process been followed? Does the outcome represent value for the company? And thirdly, if this is the best offer but not ideal, what should be done to address those risks? That is definitely one of the roles of the board when it comes to procurement matters, at least.
And what would a board ordinarily do when it concludes that the CFST or the BAC has erred?
The process defined in the Treasury regulations and legislative framework is that they have to refer it back to the BAC with the concerns listed, and the BAC will then take a decision whether they would refer it back to the evaluation committee or reassess the tender, and once that's done, they would return to the board chairperson the revised recommendation.
So it's unusual, in other words, for the board itself to reverse a decision and award a tender to a party never recommended by either the CFST or the BAC?
Correct. The board would recommend back to the BAC to perform an adjudication. They wouldn't do it themselves.
So what is usual is that if the board can't see its way clear on certain issues, it would refer the matter back to the BAC and say, consider these concerns that we have raised, and leave it to the BAC how to fix that. Is that right?
Correct, Chairperson.
It's unusual for them to go a step further and say, this is the one who must be awarded the tender.
That's correct, Chairperson.
Yes, okay.
This is an aspect which Ms. Kwinana has addressed in her Rule 33 notice. She has responded to say that the board's function is not to rubber stamp, but to apply its mind. And she also says that Air France was more expensive than AAR, and that component support was not Air France's core business. And she goes on to say that this was one of the best decisions that the board made at the time. Do you have a response to that?
I fully agree with Ms. Kinana that the board is not just there to rubber stamp decisions, but according to the evaluation, just from a process perspective, the board should have referred it back to the BAC to consider its concerns and to come back with a proposal how to adequately address it before it was submitted to the board again. Whether it was the best possible decision, I wouldn't be able to comment on that given the time. It's easy in retrospect to make pronouncements, but no, I think the board might have had to refer it back to address the concerns raised.
Is it possible that considerations of urgency, if there was some urgency, may have justified the decision of the board not to refer the matter, the tender back to the BAC, and May decided to make the decision itself, would those kinds of considerations justify this kind of conduct on the part of the board?
Chairperson, I'm convinced that there was a certain amount of pressure to conclude this matter. However, this has been going on for 3 years already, advertising, cancelling, Another week would certainly have not been
would not have had
material in any way.
Yes. Okay.
Ms. Mamela has also responded to this aspect of your evidence. Insofar as there was an implication that she improperly influenced the decision through her attendance at the CFST, she says that she's simply not that big a fish, and that she has no power to propose the appointment of any particular person to the board. Do you have any comment to that?
Influence is a difficult thing to define in this instance. I would agree with Advocate Mamela that the role of the BAC is to do their work independently and make a recommendation. The nuances of influence is very difficult for me to pronounce. I would not be able to comment on that.
Thank you. Mr. Human, I'd now like to move on to the contract itself that was concluded pursuant to this board resolution. And do I understand correctly that while for most of your affidavit you've relied on documents in order to put together the chronology, at least insofar as the management of the contract today is concerned, you're able to speak with some degree of personal knowledge?
That's correct, Chairperson.
Can you begin by telling us about the issue of the payment of an upfront?
Where do we go from
Sorry,
now?
Chair. Page 44.
Which bundle?
In the affidavit, it's bundle
The one with the affidavit?
DD 22A.
Okay. And you say what page?
44.
Yes.
And we're at paragraph 161. Can you tell us about the issue of the payment of an upfront deposit, Mr. Human?
Yes, the contract provides...
Hang on one second. Let's connect the two properly. The board makes a resolution that AAR must be awarded. Was it awarded?
Yes, Chairperson, it was awarded.
And when was that?
It was at the board's meeting dated...
Is that a separate one or the one where we have just looked at the minutes?
It's the one that we just looked at the minutes.
But wouldn't that be simply a resolution, but subsequent to the resolution, somebody needs to do the actual awarding of the contract? Would the resolution amount to the awarding, the decision to award, or was the position that the board makes a resolution to say this is the entity which must be awarded, and somebody else within the company must then give effect to that resolution by doing the actual awarding?
Yeah, Chairperson, that's spot on. The board approved the award, and then it's standard practice that a letter of award would be issued by the head of supply chain.
Yes.
It's basically a one-pager informing the successful bidder that they were successful, and it will then ensue in a formal contract process where the contract is formulated, reviewed by the legal department, and both parties sign with effective date.
After the letter awarding the contract, there would be negotiations to then conclude the contract. and then the contract gets concluded and signed. And thereafter, you get to the stage of implementation and management of the contract. Is that right? Is my understanding of the process correct?
The contract will be based on the conditions that were advertised. That becomes core to the content of the contract and to the performance indicate thereafter. In government, we are bound by the so-called general conditions of contract. It's published and regulated by the National Treasury. It's been reviewed from time to time, and it deals with all aspects from supplier management to disputes, payments, and the core concepts in contract law. In this case, it's a very specialized environment, Chairperson. Aviation and components requires specialization, and the contract articulated those specialisms.
Yes. But am I right to say after the letter of the award, there is no written contract?
Correct, Chair.
There are discussions aimed at settling the contract or putting together a contract that accords with the general terms and conditions that you are talking about.
Correct.
And whatever else may be added by the parties.
That's correct, Chairperson.
Yes, okay. So let's hear when the letter of award was, what date, and then we move from there.
Chairperson, the letter of award was issued on the 13th of May, and it's documented in paragraph 155 of the affidavit, supported by Annexion 96.
Okay, no, that's fine. That's fine. Yes.
Chair, it may be a convenient time because you've raised the issue of contract negotiations.
Yes.
And so before we get to the contract itself,
yeah,
we do have an affidavit from Mr. Mike Kenny. Chair, it's been provisionally included in the bundle at this stage, subject to your direction in due course if it became contentious. It is in Annexure 22G.
That's Exhibit 22G.
Exhibit 22G.
What page?
And the page, it starts at 3150.
I guess it wouldn't. Oh, that's the last bundle.
That's the last
which
bundle.
You said. So
there's some additional documents.
Yes, yeah,
indeed,
okay,
Chair.
okay. Yes.
And if you turn to 3154, at paragraph 20, and sorry, Chair, just to clarify, Mr. Kenny was the head of Department Technical Sales at South African Airways Technical. And at paragraph 20, he says, after the board's decision to award the tender to AAR JM Aviation Joint Venture, I was part of the team that negotiated the contract with the joint venture. I recall there being a number of meetings held during the contract negotiations, probably between 5 and 10 meetings. I recall that I attended all or at least most of them, and that Ms. Mamela was also in attendance at the meetings. She and Ms. Mbeki were responsible for the legal aspects during these negotiations, with Ms. Mbeki taking the lead on the drafting. Ms. Mbeki took an active role in the negotiations and would not just accept what AAR said. She was always trying to ensure that SAAT was protected under the agreement. I recall that at one point, AAR became unhappy about all the issues she was raising. At paragraph 23, at one of the EXCO meetings after the agreement with AAR JM Aviation had been signed, I asked to be provided with a copy. Ms. Mamela told me that I could not be given a copy of the full contract and would only be given a part of it. I took issue with this and asked why I could not be given the whole contract, and Ms. Mamela said that it was to protect me. I did not understand what that meant at the time, and I still don't understand what she was conveying. I have never seen the full contract. It was highly unusual for my request to see a contract that I was responsible for implementing to be refused.
Well, I see Miss Mbeki, a reference to Miss Mbeki here. And there has been a reference to Miss Mbeki in another context by other witnesses. And I was looking for her name to see, but it looks like this affidavit doesn't have the name. Under law enforcement, there was a Miss Mbeki, Cook Mbeki, I think she was, who was acting director of IPID at a certain stage. And so I was wondering whether it's the same person.
I don't believe so, Chair. I've been conferring with my
Yes.
colleagues, and I don't think so.
Okay. Yes, thank you.
Mr. Human, do you have any comment on that?
No, sir.
Can we then turn to the contract itself? You deal with its conclusion at paragraph 160. Can you tell us about the conclusion of the contract?
That's paragraph 160 of his affidavit.
Of his affidavit on page 44, Chair.
Yes, the contract will be in the bundle that we have just used.
Indeed, Chair. Not the one we've, not G,
okay.
no.
But for now, you want me to look at the affidavit?
Indeed.
Okay, all right.
Chairperson, an agreement was eventually reached on the content after it was negotiated and was signed by the then acting CEO, Mr. Peary, and the president of AAR, Mr. Holmes, on the same date. That was 7 July 2016. Upon
What
signature,
paragraph is that I'm looking for where you...
paragraphs 160, Chairperson.
160.
160.
Okay, all right.
Upon signature of the contract, implementation phase started.
All right. Can I ask, Chair, now I would like you please to go to the contract. It's in Exhibit DD 22F
Okay.
at page 2325.
Just give me the page number again.
Chair, the contract begins at 2318
2318.
behind tab 98.
Okay, found it.
And I'd like you to go to 2325. Will you please read that clause for us, Mr. Human?
And let's just confirm first. This is contract number 30310. Says component support agreement between JM Aviation SAPTY Limited in conjunction with AAR Supply Chain Incorporated and SAA Technical SOC Ltd. What is it dated?
On page 2333, it's dated the 7th of July, Chair.
What is the year 2015?
2016.
2016. Yeah, just before he reads, we just need to identify it so that the reader of the transcript understands what document it is.
Thank you, Chair.
What clause did you want him to read?
4.26, Chair, on page 2325.
Chair, the clause 426 reads as follows. Prior to the commencement date, JMAR will invoice SAAT for the deposit. SAAT will pay the deposit by way of an irrevocable standby letter of credit from a bank acceptable to JMAR and in form agreed by JMAR. The parties agree that JMAR will have the right to set off any SAAT invoices not paid by its due date against the deposit, and SAAT shall, when necessary throughout the term of this agreement, replenish the deposit and maintain the amount invoiced by JMAR prior to the commencement date. and at the time of expiration of the termination of this agreement, JMAR will arrange for the release of the deposit to extend that the SARD has paid all outstanding invoices.
Thank you. What's your understanding of that clause?
Credit arrangement, usually by a letter of credit by an acceptable bank, must be furnished to guarantee that in the instances of non-payment, JMAR could present such credit letter to a bank to make good on outstanding invoices.
And, sorry, Chair.
Would that be a normal practice for these kinds of agreements?
Yes, Chairperson.
Okay.
And tell us how that clause was implemented.
In this instance, actual cash payment was paid, not just a letter of credit. JMAR invoiced SAAT for the value of 3 months power by the hour costs, and that, Chairperson, amounted to 4.382 million US dollars at the time.
So in rands, that would have been
just over 60 million rand, more or less, if we accept the exchange rate at 14.5.
Yeah, okay. So you say this was given to them in cash?
Correct. Cash meaning a transfer, a wire transfer to the bank account.
Yes, as opposed to giving them a letter, which is the normal practice.
Correct, Chairperson.
Okay.
I was just worried that you were interpreting this as maybe small
think I may
bills
have been
in
thinking of
smaller denomination dollar bills.
Yes. And what was said to be the justification for departing from the norm in this regard, if you have been able to gather any justification from the documentation?
Chairperson, I was unable to determine from the documentation any logical argument. To the contrary, my interpretation is to part with valuable cash would certainly put a strain on the cash flow. Secondly, my understanding of...
When there was no need.
Correct, Chairperson. The contract certainly provides for acceptable means. Making a cash payment does not really make a lot of sense.
But would it also not put SAAT at risk in case JMAR fail to perform and they already have cash? I mean, they have been paid. It's not just a letter. If they fail dismally to perform, then SAAT would be prejudiced.
That's correct, Chairperson.
Okay.
Thank you. Mr. Human, have there ever been any drawdowns from that deposit in order to offset outstanding invoices?
Yeah, Chairperson, to my knowledge, there has never been an offset against the deposit for unpaid invoices during the duration of this contract.
You refer in your affidavit to a review that was done of the contract in 2018.
Correct.
That's at page 45 of your affidavit, at paragraph 166. Can you tell us what the purpose of that review was and what it found?
Certainly. Chair, the intention of the joint contract review was to assess performance, and these spoke specifically to matters that that SART found not to be beneficial. The first instance, if I may expand a little bit on it, give me, Chair, just want to make sure if it's not listed. was the long turnaround times for repair of components. We keep statistics, and so does the service provider, and we noted that some repairs were outstanding for longer than 600 days. Now, for a maintenance organization, it's virtually unheard of that you will be without a spare for almost 2 years. 600 days is just short of 2 years. So we addressed performance-related matters like this. At the time, there was just over 930, I believe, items outstanding for excessive time. That would be for 6 months or longer. Secondly, incorrect invoicing. The contract provides for 35% of beyond economic repair cost, but we've noted that on several invoices, the amount were charged at 100% plus a markup plus a handling fee. And the intention of this review was to correct that, cancel the invoices, give us a credit note, and bill 35% as per the contract terms. The next issue that we raised was the excessive penalties. SART has been sloppy in the administration of this contract in the sense that it has determined a return date, and if a core unit is not returned within that date, a penalty is raised. Up to now, SART has paid 69 million rand in penalties, 69.6 million rand in penalties for late return of cores. Our intention was to point out to JM Aviation, but the same kind of penalty does not apply when components take 600 days to come back to SART, and we would like to have some kind of equalization of the terms and conditions. Also, we noted that there has not been any NIP obligation benefits. We wanted to address the matter that the NIP contribution needs to be addressed and be accelerated, since the contract was already halfway through its term. And then another item was the...
Can I just pause you there, Mr. Human, and just confirm that the NIP obligation was a requirement in the RFB?
Correct. The NIP obligation was as per standard bidding document number 5. It's a standard part of the RFP pack.
Thank you. Continue.
And then, Chairperson, the reciprocal work that was a part of the critical criteria in the award was that AAR would provide work to SART to be performed at its workshops, and up to now, no such reciprocal work has come to the fore. These, in short, Chairperson, was the main discussion points that we thought was stipulated in the contract, and we wanted the performance in these areas to be addressed.
Can you also just explain the issue of BER costs?
The discrepancy between the RFP was that the ask was for a 30-70%. It was advertised in the bid as that the BER ratio would be 30% and 70%, yet in this contract it is 65-35%. And then the issue that we addressed is that the charges thereof were made at 100%. This issue was then addressed at this meeting.
And was that also one of the critical criteria, the 70-30 ratio?
It was a critical criteria in the bid published on the beginning of December 2015.
Whose responsibility would it have been on SART's side to make sure that SART's rights in terms of this contract were properly enforced against JM/AAR?
Chairperson, the contract implementation is the responsibility of the contracts unit in SART. And then on the practical side, to return a core unit would be the business unit. It will be workshops. But
Yes.
enforcing the terms and conditions is the responsibility of the procurement or supply chain unit.
So that's the unit that Ms. Memela was heading.
Yes, sir.
Yes. Okay. Now, you said that with regard to penalties, the contract made provision for penalties to be applied against SAT when there were delays on his part, but the contract did not have similar penalties to be applied when there were delays on the part of JM/AAR. Do you know whether having that kind of situation was something quite unusual to be allowed by SAT in other contracts that it does? Do you know whether usually there would be reciprocal provisions relating to penalties?
Chairperson, I know that from my experience at Treasury, that the general conditions of contract specifically specifies penalties for poor delivery. And it is therefore strange that this is a very one-sided contract applying penalties on SART, but not on the other side. I'm used to contracts that protect the interest of the procuring agency and not in this fashion.
And it seems that it would be something quite easy to pick up for anybody that would be looking after the interests of SAT. If they see that there are penalties that would be applicable to SAT in certain circumstances, logically they would think, what about JM/AAR when they have delays? And therefore it's difficult to understand how they could see these in regard to SAT but not think about ensuring that there were similar penalties against AAR.
That is correct, Chairperson.
Okay.
Thank you, Chair. Mr. Human, what in your understanding are the services that are provided by JM Aviation?
JM Aviation, the partner.
Indeed.
Yes. Chair, my understanding is JM Aviation is responsible for the supplier development component, or that was part of the tender, that the JM Aviation would have a full-time representative on premise to support the day-to-day operations and to ensure that the NIP obligations are met that was stipulated in the contract.
And to what extent has that happened?
Up to now, we have received no, zero supplier development beneficiation. Also, no agreement on NIP has been signed with the DTI, and we have had zero reciprocal work on the contract. All three of those are have not been delivered on in any shape or form.
And what's the total amount that SAA Technical has spent so far under this agreement?
Chair, I did attach a annex with the exact amount, and from memory I believe we are just about at the R1 billion, just past the R1 billion. At this rate, over the duration, the contract will probably end at R1.8 billion if I project the current rate of expenditure.
Yesterday, Ms. Sambo, I think, told me what the value of the contract was. Does that accord with the value of the contract as you understand it?
Chairperson, the contract value is stipulated at 1.3 billion.
Yes.
But at the current rate, we will end at 1.8. It
Yes.
will overshoot with at least $500 million.
What would you say is largely responsible for that, that you will go so far above what had been envisaged? Is it?
Chairperson, 3 reasons. When this contract was signed, it excluded the Airbus 330s. 6 aircraft was added about a year into the contract as a contract amendment that increased the value. Secondly, the fact that SALT has lost a lot of its capability at workshops and the number of repairs has increased. Third aspect is the incorrect pricing. And fourthly, the harsh penalties that was imposed on SALT will contribute to the R500 million increase.
Bearing in mind or remembering the concerns which management had expressed about giving the contract to JM and AAR, and looking at the fact that it's been, 2, 3, 4 years, 2, 3 years of implementation, are you able to say whether those concerns have materialized, or actually no, things as far as those concerns are concerned have worked fine? I'm now talking about concerns relating to lowballing and so
Yes. Compared to Chairperson, no, I can't really comment in a scientific way, but I can give you a gut feel if that will satisfy
Yes.
in any way.
Okay, for what it's worth. It's
for what it's worth.
Yeah.
If this contract was implemented as intended, it would have been an excellent contract. So 2 considerations is SALT's ability to be disciplined, to avoid the penalties would have been beneficial. The concerns about lowballing, I think, is valid if I look at the incorrect charges, and I hope it is really administrative error and not intentionally incorrectly invoiced.
Would you be able, given time, to go back and do the homework of seeing whether those concerns have materialized or not? Because it might be helpful would that be something that you could do, or is it difficult to do?
No, Chair, we have gone far with that analysis, and I do have a calculation of the BER difference in cost that I could certainly finalize and submit to you in the next 2 or 3 days.
Okay.
To comply to your request, Chairperson.
Okay, I think that would be helpful. Thank you.
Thank you, Chair. Just on the issue of cost, you said that that SART has spent just over R1 billion. How much would have been paid to JM Aviation?
According to the contract provisions, 5% of all revenue would be accruing to JM Aviation. 5% would therefore be around R53 million.
Thank you. Chair, we've also received an affidavit from a representative of the DTI, and I would like to take you there, Mr. Human.
That's Department of Trade and Industry.
Department of Trade and Industry, indeed.
Yes, okay.
It's in file DD22G. And it starts at page 2972. three aspects I'd like to draw your attention to.
Sorry, just the page number again,
It
sir.
starts at 2972.
2972. Thank you.
It's an affidavit from Mr. Lionel October, who is in the employ of the Department of Trade and Industry in the capacity as Director General. And if I can ask you to turn to 2976. At paragraph 16, Mr. October says that SART had a duty to not only inform the DTI of the agreement between it and JM Aviation, but had a duty to do so within 5 working days after award of a contract. The SART, in the present instance, failed to act in accordance with this requirement, since we understand that the agreement between SART and JM Aviation was entered into in 2016. Does that accord with your understanding?
That's correct, sir.
And then if we go to paragraph 19, the first paragraph spoke about SAAT's obligation. 19 says, in the present instance, despite the fact that there was a duty on JM Aviation to immediately inform the DTI that the particular contract was awarded to it, it failed to inform the DTI. So does that too accord with your understanding?
Correct, yes.
The last aspect I'd like to take you to is on page 2977, the following page. And paragraph 27. That paragraph reads, I should also place on record that Mr. Kirtland, that's an investigator of the Commission, requested information in relation to Lufthansa's performance of its duties flowing from the obligation agreement which was entered into between the DTI and Lufthansa. This agreement was signed on 17 February 2013 and is attached hereto marked as Annexure I. According to the DTI's NIP records, there is no indication that Lufthansa is non-compliant in relation to its current NIP obligation. In this regard, I have attached hereto a printout of Lufthansa's performance status as at 30 September 2019 and have attached same hereto as Annexure J. The DTI has never received correspondence from SART in relation to Lufthansa's non-compliance with its current NIP obligation. Does that come as a surprise to you?
I take it as fact from the Director General of DTI.
Thank you. The last matter on the contract, Chair, is that we've managed to locate the round-robin resolution that you referred to. If I could beg leave to hand up a copy and to hand one to the witness.
Yes.
It's to be inserted in file in Exhibit DD22F at 2302.1.
Okay. Thank you.
This reads that it's an excerpt from the round-robin approval process of the SAA Bid Adjudication Council held on 6 May 2016, and it reads that the BAC resolved to note SAAT's intention to award the tender for aircraft component support services on 88 chapter coverage for both Boeing and Airbus fleet to Air France Industries for a period of 5 years as per Chapter 5 of the SCM policy. The value of the contract...
Chapter 25.
As per Chapter 25 of the SCM policy. The value of the contract for a 5-year period with Air France Industries is estimated at just over 1.3 billion rand. True excerpt of the round robin. Mr. Human, I asked you earlier about the fact that the BAC had decided simply to note the intention to award the contract. Your response then was that all they could do was note it, because they didn't have quorum.
Correct.
This is the round-robin resolution, and it still says that they note the intention to award. What's your view of that?
My view is that the duty was to recommend this to the board and not just noted, as their function is to adjudicate, and if it's within their delegation of authority, at the moment that is 50 million rand, anything less than 50 million they can award, more than 50 million needs to go to the next structures.
Well, let me first ask, why is that resolution on SAA letterheads as opposed to SAAT?
Chair, SAA and its subsidiaries share a central BAC. So all tenders for air chefs, SAAT and Mango and SAA are adjudicated at one central BAC. It is called the Global or Group BAC, and it's another form of oversight to make sure that there is at least line of sight of what is attended, evaluated, and then for adjudication.
You may or may not be able to comment on this. I would have expected them nevertheless to use SAT letterheads when it's a tender relating to SAT, and use an SAA letterhead when it's a tender relating to SAA, and so on and so on.
Chairperson, I believe the reason why it's on a SAA letterhead is because the secretariat of the BAC is based in SAA.
Yeah, so it may be that for them it's not a big issue, but probably what they should be doing is using letterheads for the particular entity if the tender relates to a particular entity, even if the committee, the composition of the committee is the same for all the different entities. But for them, maybe it's not a big issue. But we must take it as the relevant BAC's resolution.
Yes, Chairperson, the identification would be in the heading SP 462/15, would then be able to assign it to which entity is. But your advice is solid, and I will certainly raise it with the BAC after the proceedings.
Okay, no, thank you.
Thank you, Chair. I intend to move on from the topic of the components tenders now, Chair.
Yes, that's fine.
Thank you. Mr. Human, I do understand that there was some litigation that arose out of this, this tender. I don't intend to spend time on it, but can you briefly tell us what that litigation involved?
Certainly. Upon issuing the letter of the award and a letter of regret to the non-successful bidders, Air France formally raised a litigation proceeding. It was heard in the High Court of Johannesburg, and the long and the short of it is that the court upheld the decision of the SART board to award it to AAR.
And my understanding is that that was brought on an urgent basis.
That's correct.
And it was for an interim interdict.
It was for an interim interdict.
Do you know whether there was ever any final review proceedings?
No, there was no further action taken by Air France. In fact, Air France informed SART later on that they have no intent to pursue the matter further.
So Air France was aggrieved by the award of the tender to JMAAR and took the decision to award the tender to JMAAR on review in court. And the outcome was what you have just told me.
Yes, Chair. The Air France did raise the matter to seek interdict not to discontinue the service while this process are unfolding.
Okay. Okay, no, I think I may be missing something that might have been said while I was looking for something here. So what Air France wanted to achieve was an interdict of the implementation or against the implementation of the tender in favor of JMAAR. Is that what it was?
Correct, sir.
Okay, and that was dismissed.
Yes.
And as you understood the position, they wanted an interdict pending a review application.
Interim interdictory relief.
Yes, okay. No.
Indeed, Chair.
Thank you. Okay.
And as far as we're aware, there's no judgment on a final review.
Yes. No, that's fine. Of course, it would be important to know, to get the affidavits that were used by Air France so one can see how much information did they know about what went on.
Indeed, Chair, they are included in the bundle.
Okay,
We've included both the affidavits and the judgment.
Did they know quite very little?
Not what the Commission knows.
Okay, all right.
Mr. Human, can we then turn to the portion of your affidavit where you deal with the Swissport ground handling contract and GPU sale? That's at page 52 of DD 22A, starting at paragraph 177. And before you take us through it, I think it would just be helpful for you to help us with some concepts. What are ground handling services?
Ground handling services is those services on the apron at the airport, positioning power units, making sure that the towing services are available, tugs, that kind of thing. The loading and unloading of aircraft, baggage transportation, and other equipment like steps, ramps, that kind of equipment falls under ground handling.
And what are GPUs?
A GPU is a ground power unit. Aircraft needs to maintain the power supply. That can either be done through running the engine of the aircraft, which of course is quite expensive. Jet fuel is a cheapest and slightly more expensive than the normal 95 unleaded version that we use. And therefore it makes sense to make use of a GPU, a power unit.
How does that work, the power units? Do they connect to some electricity, or
yes?
If you don't use the aircraft engine, so how does the aircraft get power?
Yes, so it's almost like a mobile generator. It's usually on a carriage or on a trailer.
Oh.
It works with fuel or diesel, and then it's got electrical connections that is plugged into the aircraft to power it. There's two versions: the mobile and then fixed power units. Obviously, they are limited to the maintenance bays, but the units we are referring to here is mobile. They can be towed behind a tractor or a vehicle and positioned at the aircraft where they are needed.
So this GPU would be, or that kind of generator would be used when the aircraft has touched down and is parking?
Yes,
or
sir.
Would it be for the time when it's the aircraft is parked? Would it be for the time when it's parked, or only when there's a need, maybe the engine must run or whatever must run?
Chair, it's usually when the aircraft is parked. Sometimes a foreign carrier would arrive in the morning and only fly out 10 o'clock at night. So for a period of 12 hours, it would probably require the power unit. In other instances, shorter maintenance events can take 2 or 3 days, and then the power unit will be connected so that the engines don't need to run. Especially if work on the engine itself needs to be done, then you'd like to use a other power source than running the aircraft's own auxiliary power unit or APU.
Basically, it provides the power that enables all the electricity in the plane to work without using the engine.
And that's correct, Chief.
Yes, okay.
And can you talk us through the process by which the ground handling contract currently in place was awarded?
Yes, Chair, this contract was run by SAA itself, not by SAAT. It was published in May 2011, and then on a board resolution on the 31st of July 2012, it was decided that the GPUs owned by SART would be included in this process. It was for a 5-year period from 2012 onwards, and Swissport was awarded the tender for the ground handling services.
And so when was that awarded?
It was awarded on the 31st of July 2012. I'm on paragraph 177, Chairperson, of the affidavit.
I see something here that says Swissport was partially awarded the tender at 178. What does that mean? What did it get and what did it not get? Or is that something you might not be familiar with?
I have attached, Chairperson, a annexure, and for the moment it eludes me what was included and what not, if you indulge me.
Chair, perhaps I can assist. It's in the resolution,
yes,
which is in file
yes.
DD 22G.
Yes.
Effectively, Swissport was awarded ramp handling, PAU and wheelchair and document verification, and Bid Air was awarded busing.
Okay, thank you. Okay. Would that mean that the tender was split between 2 bidders?
Correct, Chairperson.
Okay.
And was a contract concluded with Swissport?
No, the contract was not signed. I'm unsure why. I'm not aware why the contract was not signed.
But the performance of the contract continued
Correct,
in the meantime?
Yes.
Okay.
Despite the fact that there was no signed contract, services were rendered.
Okay.
And how much was paid to Swissport without a contract in place?
1.139 billion rand.
What was the value of the contract of the tender before it was awarded? Do you know that?
Chairperson, not off the cuff.
Yes.
We can.
Chair, it is contained in the same resolution I just referred to.
Yes. What does it say?
The total was 1.4 billion, but that includes the amount to Bid Air, which was 81 million.
Oh,
so the amount to Swissport was a total of about 1.38 billion.
Okay, thank you. Yes.
Mr. Human, you spoke about SAAT acquiring GPUs. Did it acquire GPUs?
That's correct. APUs were purchased and it was used for operations in SART during its maintenance operations.
And do you know how much SART paid for the GPUs?
Yes, we have an attachment that indicates what was the purchase value, the depreciation, and the book value. Chair, I would appreciate if colleagues could just refer me to the correct.
Can I ask you to go to Exhibit DD 22B?
DD 22B.
B.
Problem.
Have you got the page number?
Yes, it's 684.
Yes.
Can you see what the price per unit and the total price was?
Yes, Chairperson, the purchase order contained on this page indicates that the value that was purchased at VAT inclusive, 9,193,981 rand and 20 cents. Just
Yes.
short of about 10 million.
Yes. Okay.
Now, you've told us about the period between 2012 and 2016. Tell us what took place in 2016.
A decision was then taken to is this the purchase of there was a decision taken then to sell the GPUs as part of the ground handling services to Swissport, and this resulted in SART selling the newly acquired GPUs shortly thereafter.
You speak in your affidavit about a contract being concluded with
Are we
Swissport.
going back to the affidavit?
Sorry, Chair. There's just so many files to move between. We are back in the affidavit at DD 22A.
Yes. What page?
We're at
52?
page 52,
Yeah.
and we're at paragraph 180.
Yes.
And we talking about the conclusion of a contract with Swissport. Are you there?
Yes, sir.
So tell us about that contract.
The SAA board agreed to award it to Swissport for 5 years. The process that was followed, I have not first-hand knowledge. The part that I do have knowledge and documentary evidence is concerning the sale of the GPUs that was a condition of this award. It provided that, Chairperson, the Swissport will arrange for the purchase of these GPUs, and I've tried to formulate it in paragraph 184 of the affidavit. The sale took place at book value. The amount that I've mentioned earlier, Chairperson, was the purchase price of 9,139,000 odd per unit. After depreciation, the amounts, the units were then sold at the so-called book value.
Sorry, before we get there, on the issue of Swissport having concluded having performed services between 2012 and 2016 without a contract, and then having concluded a contract in 2016. Do you know if there was a tender process that preceded the conclusion of the 2016 contract?
I do not have first-hand knowledge of the tender process, unfortunately.
Okay. Chair, in Ms. Hofmeier's introduction this morning, she referred to the fact that Swissport had referred to an affidavit they had previously given. I would just like to put their explanation of this process to Mr. Human. Yeah. The summary of Swissport's position is that it was awarded a 5-year ground handling tender in 2012, but no contract was concluded. Swissport struggled with South African Airways to get a contract signed during the period from 2012, and in the interim provided services on a month-to-month basis. They did so without a signed contract. By December 2015, the 2012 tender had therefore still not been implemented. A contract was then eventually concluded.
I'm sorry, do they say the contract had still not been signed? Because otherwise they were implementing it without a contract, isn't it?
Indeed.
Yes, so the contract had not been signed by end of 2015.
By the end of 2015.
Yeah, okay.
They then say that a contract was eventually concluded in March of 2016 for 5 years, from 2016 to 21, which Swissport says was rooted in the 2012 tender.
That's very strange, isn't it? The bids were invited in 2012 or 2011 or whatever time, and the tender was awarded to Swissport. No contract was signed, but they rendered services and were paid as if there was a contract. And then in 2016, a contract was signed without a new tender, and it was signed on the basis that it was the contract which should have been signed in 2012, but
Chair,
it was providing for a further 5 years.
For a further 5 years.
Is my understanding correct, Mr. Human?
I wish I could say otherwise, but yes, it is correct.
Yeah. And what was the value of this 2016 contract now compared to the 2012 tender? Mr. Human, is that information you have at hand, even if it's an estimate or not really?
Chair, this is coming in the evidence to follow,
okay.
But it's in the region of 1.2 billion rand.
So they would end up getting 1 comma something billion times 2.
Correct, sir.
Okay. All right. Yes, Mr. Mpikiwe.
Can you, and I'm now back at your affidavit on page 53, where at paragraph 182 you describe the clauses in the 2016 contract related to GPUs. Just explain or read those clauses for us.
Certainly. Chair, it was recorded that the board resolution had the following resolution. Swissport SA to acquire all GPU equipment that has been purchased by SART, and Swissport SA to enter into a contract with a BEE company that has representation of black, women, youth, military veterans and disabled persons, from which Swissport will purchase all the equipment required for SAA contract.
And who were the GPUs sold to?
This GPUs was sold to JM Aviation.
And for what price were they sold to JM Aviation?
I'd like to quote the correct amount, Chairperson.
I can take you to the exhibit. It's exhibit DD 22B at page 844.
Yes.
Are you there, Mr. Human?
And so page number?
844 in DD 22B.
Apologies, Chair. Chairperson, the invoice for the GPUs amounted to 248,000 per unit, and the total was 3.392 640 million, 3,392,640 rand.
And do you know what the book value was at the time?
I do.
And I can refer you in the same file to page 694.
Chair, the book value at the time of sale was 7,968,117.
So that's more than double the price for which it was sold.
That's correct.
And can you tell me what is a book?
Just hang on 1 second. So, Swissport, the buyer here was JM Aviation,
That's right, sir.
and the seller was Swissport. Who was the seller now of the GPUs?
Sold these GPUs to JM Aviation.
Swissport sold them.
No, SAAT.
SAAT. Okay.
To JM Aviation,
It's been
and then Swissport bought them from JM Aviation.
and Swissport bought them for more than double, almost more than double the price that
Yes.
JM Aviation had bought them from SAAT.
Yes, Chairperson, if I may, South bought these units for 9.1 million. Shortly thereafter, it sells these very units for 3.392 million to JM Aviation. It's actually worth, according to our financial records, 7.968 million. This transaction is demonstrating that we have sold for next to nothing a unit that was more or less worth double.
Yes.
Thereafter, JM Aviation sells these units to Swissport.
For almost more than double what they paid to SAAT. Is that right? Yes. You agree, Mr. Human? I just want to make sure that because you are the witness. Is that correct? Is my understanding correct? SAT.
I don't have a document what Swissport has paid
To
to
JM.
JM, but
Yes.
in the forensic report that is attached as the next, there's reference made to the sale.
So from that report, it looks like Swissport paid more, much more for them than paid to JM much more for the same thing than JM paid to SAAT.
Yes, Chairperson.
Okay.
So my evidence is based on the content of the forensic report,
Yes.
and the learned colleague could maybe just point us to what was the amount then paid by Swissport.
Indeed.
Yes. It looks like he has got it ready.
Chair, the amount is 9.4 million that was paid by Swissport. But this is evidence that Ms. Hofmeyer
That
is
will be-
going to
will be led, yeah.
lead over the next couple of
Yes.
days.
No, that's fine, but it's good just to
Indeed, Chair.
connect the story properly. So the question would be, what was going on with SAAT, one, selling the units in the first place, and secondly, selling them at almost, half the price, am I right, or even lower than that, to JM?
Less than half to
Less than half.
to JM.
To JM, and selling the units when they were still quite new as well. And I think that's what Mr. Human said. And then later on, they leased them from Swissport.
Indeed.
Yeah. And in terms of the documentation that you have come across, you could not find anything that justifies this merry-go-round that was going on.
To the contrary, Chairperson, after the sale, SALT has to date paid 8.42 million rand in leasing fees for these very same units that we owned and now lease back.
Now, and are you able to say what SAT's loss has been when you look at that, plus the fact that they sold the same units to JM for less than half? Are you able to say what the loss is when you take all of those into account?
Yes, Chairperson. The capital loss from the original purchase price to selling price was just over 6 million. And the subsequent loss due to unnecessary expenditure was a further 8.4 million in leasing costs that
Yes.
would have been prevented if we just retained the asset. So total loss would be 14.5 million or thereabout.
Sure. I take it there will be evidence as to who were the people responsible for all these decisions. Yeah. Okay, all right.
On the issue of the leasing back, Mr. Human, the fact that they've been leased back at this cost, what does that say about the decision to sell them?
It's an irrational decision to sell them, Chairperson.
And it suggests that SAAT still needs those GPUs.
Absolutely.
Chairperson,
Well, maybe Ms. Hofmeyer will remember. Didn't I, or maybe you were not involved, didn't I hear evidence along the same type of thing when Mr. Nene was giving evidence with regard to SAA about, I think, Airbuses, and that there was an idea that they must be sold and then leased back. But anyway.
Chair, it's before my time, but Ms. Hofmeyer is nodding.
Okay, all right. Thank you.
Chair, that concludes my questions for Mr. Human.
Yes. Okay. Mr. Human, thank you very much for coming to give evidence. We'll call you back if a need arises, but thank you very much, and you are excused.
Thank you, Chairperson.
Thank you. We are going to then adjourn. Tomorrow, the plan is that Ms. Memela is supposed to be here. Is it just her, or there is another witness?
It's just her, Chair.
Just her.
The day has
Yes.
been set aside for her.
Okay, at this stage, you are not aware of any developments that might exist with regard to her intentions?
We've received nothing, Chair.
Yeah, okay. All right, we'll adjourn for the day, and tomorrow we'll start at 10 o'clock. We adjourn.
All rise.